The morning started out with legal arguments. First, they argued about the state's desire to call a lawyer who was the guardian of the Dulos children. This lawyer requested a protective order. He was concerned about the negative impact on the children. It was mostly the state arguing, trying to convince the judge to give them what they wanted. And the judge said, look, the evidence you're trying to get out from this witness has already been introduced. The jury already knows all of this. The judge ended up granting the protective order. And I noticed the state does this a lot. They've been doing this the entire trial. And at first I thought, well, they have to show that the investigation, it was complete, because if they don't show that, then the defense is going to jump up and say, well, it's incomplete. What about this, that, and the other thing? But I don't think that anymore. I don't think that's what they're doing. It looks like they are repeating evidence to drive home certain points and to make it look like they have more than they do. That's my opinion. I'm not in anybody's head, but that's what it's looking like to me now. And the other thing that happens when you throw that much information at a jury, the jury doesn't know what to latch on to and what not to. And important details get glossed over, like who is the other male contributor of the DNA that was all over the items in those garbage bags. Then they argued about Michelle's cell phone. Initially, her cell phone was seized without any probable grounds. And even the state agreed that, there were no probable grounds. But they took her phone. They had no warrant. And so that information initially was excluded. So then the police went with a different warrant, slightly different. So instead of getting her actual cell, they wanted to go to AT&T and get all of the records that belong to the Troconis family. And there's this family plan. So it would be the mother, the daughter, right? Several family members. So the police went to a judge to try and get these records. This judge had already said, you can't bring this stuff in. The police went, they said, this is different. And that other judge denied them. So what do? They get somebody else to go to another judge. So basically they're judge shopping, and there's a little box on the form that you tick off that says this has not been heard by any other judge. This prosecutor went in front of another judge and argued to get these records from AT&T. This looks like it may be the fruit of the poisonous tree. It's definitely judge shopping. And boy, it's walking on the razor's edge here. The prosecution argues it's not and cites independent source. Both the prosecution and the defense argue over who has the burden of proof. I have a question. Is the state working this hard to find out whose DNA was on Jennifer's bloody shirt? There's an unknown male. I'm not talking about Pawel. It wasn't Fotis. It wasn't Pawel. It was an unknown male. Are they working that hard to find out who that person is? And why is it that no other samples from other people, potential suspects, were submitted to the forensics lab for comparison? What the heck is going on with that? Maybe my question will be answered later in the trial. I don't know. The defense argued, these records contain tons of private information between Michelle and her minor daughter and multiple family members. It has nothing to do with anything. This is an overreach. They just go back and forth. Now, why is this important? You don't want the state to be able to just go into your phone records. Hey, I suspect your sibling was up to no good or maybe committed a crime. So I'm just going to go check all the family members' phone records. The defense argues it's an overreach. So the law does draw some lines, and it's important to uphold those, not just for a specific criminal defendant, but for all of society. The judge addressed the burden of proof and sided clearly with the prosecution on that. The judge believed that it was an independent source. Then they got into the timeliness of all of it. And it comes out that the warrant for these phone records was applied for after the start of the trial. So it's not like the defense could argue about it in advance of the trial. It happened after the start of the trial. The judge spoke to the balance between deterring police misconduct, which is really important, and making sure that the jury gets to hear and consider all of the evidence. So the judge ended up allowing the records to come in. Sergeant Jamie Pierston testified. She's from Major Crime. On June 5th, 2019, she was one of the people who went and searched Sturbridge Hill Road. This was Pawel's worksite. They noted a dumpster, a shed-type building out back, and that the building was unoccupied. This is many days after the disappearance. That took place on May 24th. So if somebody had done something wrong, there was plenty of time by then to have disposed of evidence. But these are CSIs. They can find all kinds of things, even well after a fact. So they searched the dumpster. Don't envy them. They spent hours searching this dumpster. They found nothing. They didn't state whether or not they used luminol inside the house or inside the shed. It was just they searched and they didn't find anything. And the defense got up and asked, "Did you look for video surveillance?" And they said no, they did not. First, she said there was no video surveillance at that residence. But the defense asked, "But did you search maybe across the street?" And the officer said, "No, they did not. We know because the defense introduced evidence earlier that there was a surveillance camera across the street. And in fact, that surveillance camera showed that Pawel was not there when he said he was." The next witness was the general manager of the car wash on West Main Street in Avon, Connecticut. In August of 2019, police attended that car wash and asked to review his surveillance footage. I'm curious, as this wasn't done until August, what was it that caused the police to go and look there at that car wash? By that time, had Pawel told them, "I noticed my truck was clean. They washed my truck." And the police then went looking for car washes. By that time, had they had cell phone records? Or had Michelle told them that Fotis went to the car wash? And I'm asking this because Michelle told police things that gave them leads, and she volunteered information that gave them leads, like telling them before they searched her house, she was the one who told the police, "Oh yeah, we wrote these timelines." She was the one who disclosed that. It wasn't that the police found them and then she said, "Oh, this is what they were." She initially told them. So I'm just curious whether they went to look for that car wash surveillance information because Michelle gave them the information, or if they found it some other way. And that wouldn't make it wrong or inadmissible. It's just interesting to me that she is the one giving them the information they need to conduct the investigation. If she was trying so hard to hide, why would she do that? Anyway, I don't know the answer to that. There are multiple cameras inside and outside of this establishment. And the prosecution showed video from May 29th of the Toyota Tacoma with those unique running boards going to that car wash. And that occurred shortly after 9 a.m. Then they showed another bit of footage that showed somebody who looks like Fotis coming in at 2:28 p.m. to pay. Then the prosecution moved on to the log sheet, and the car wash takes down the names and phone numbers of the customers and whether or not they've paid or not paid. And there are several services. So there's the quick just in and out car wash, or you can get a full detailing which requires an appointment and you leave your vehicle there for the day, or you can get your regular car wash plus other services. So there are 3 different services and you can get 1, 2, or 3 of these services. It was a bit confusing because they were talking about you can get a full service which only includes a quick interior, or you can get a full detail which is appointment only, or you can get your car wash and then these other additional services. You can get 1, 2, or 3 of these. The defense got up and was asking the questions about the Walmart. So you know that issue is going to come out. He's saying the Walmart is right here also on this street. It's all part of the same parking lot. There's no visual obstruction between the car wash and the Walmart, no big trees in the way and all that. And so if you're the jury and you haven't heard anything, you're hearing about this car wash and that there are no obstructions between a car wash and Walmart. I mean, you don't know where that is going. Then the defense says, oh, by the way, the state didn't actually play the entire video for the jury. So I'm going to play that entire video. The defense played the video all the way through, and he points out 2 things. One is that when you leave the car wash, there's one way you can drive to go get your car detailed. And then there's another way that you drive out to, say, go to Walmart or just go back out on the street. And he didn't really go further than that except to get the witness to say that when the Tacoma was driven to the left instead of like off to Walmart, that the person driving the Tacoma, the person moving the vehicle, was an employee, wasn't the owner of the vehicle. And then the defense brought out another interesting little thing, and that is that the blank space on the log that the prosecution was focused on, it showed 8:44 a.m., not 9:12. The manager did say, well, there's an 8-minute delay in the time of the video. 9:12 and 8:44 is a lot longer than 8 minutes. And the defense continued on with the manager through this log, saying, well, you can't really tell which services this person got because it says ×2 service, not the full ×3, not an appointment for detailing, all of that. And then the defense pointed out that there was a Toyota Sienna that came in at 8:44 a.m. and this blank spot and these services could have applied to that vehicle. And then the defense replays the video where the man is paying and the man pays cash. I mean, if you were covering up a crime and needed to pay for a service to help cover the crime, you would probably pay cash too. And then it was just left at that. I mean, I think I see where the defense is going. But, Pawel also testified that his car was clean, and it would be pretty weird why you would take your employee's vehicle to a car wash. So we'll see where this goes. I don't have anything to say about this. So I'm expecting a little more than that about the car wash. Maybe it'll come from a different witness. Some people might find the arguments between lawyers boring, but one of the arguments they had this afternoon was, to me, riveting. The defense was concerned about a medical expert testifying based on what the police said, rather than having the medical expert testify based on that expert's knowledge. This is another one of those things that is important to everyone, not just a specific defendant. You can't have the police give a narrative and then have an expert come and testify based on the police narrative. The narrative would end up being treated as fact when it is not. And you've got the weight of an expert behind something that isn't evidence at all. And that's dangerous. Then the police could say whatever the heck they wanted to say. You can't base a professional opinion on a layperson's narrative or opinion. You need to look at the actual evidence, not merely what somebody says that they think. To me, this is just astonishing that this idea would even be entertained. The defense also complained about the timing of this. The prosecution waited until New Year's to throw this at the defense, and that gave the defense no time at all to go get their own expert. The defense argued that there were falsehoods in Kimball's warrants, one being that arrest warrant, and basically said it's not fair to have testimony that relies on false information. He went further than that at points and called them lies. Detective Kimball's lies. That's a pretty brave thing for a lawyer to say in court. Usually you hear some softening, like calling it a mistake. The defense pointed out he can't cross-examine an arrest warrant, which is essentially what he would be needing to do if the testimony given was based on an arrest warrant as opposed to medical evidence. On the issue of timing, the prosecution said, look, this doctor was consulted before, like way back in 2020. And the defense knew what the state's position has been on Jennifer Dulos' status all along. So the fact that we would do this shouldn't be any kind of a surprise. The prosecution suggests that the jury can decide on the weight of the evidence. Well, that may sound like a reasonable argument, but when a jury hears doctor, when a jury's hearing from a witness who's touted as an expert witness, it's going to hold more weight. This isn't somebody off the street who just thinks something. The prosecution points out that an expert witness can rely on things that are not admissible in order to come to a conclusion or an opinion and then testify about that opinion. But that's not quite what this is. That is not actually what the defense is objecting about. Both the prosecution and defense cited the same case to back them up. But the defense distinguished the case by saying in the case cited, the medical expert had actually done an autopsy on the victim and therefore was basing the opinion on much, much more than just what somebody else said. So I was on the edge of my seat, waiting to hear what the judge was going to say. And what he said was that to decide the ultimate issue, an expert is actually not necessary in this case. The jury already has more information than what the expert could testify to anyway in order to determine the ultimate issue. The judge granted the motion in limine, and thank goodness for everybody who has to defend themselves against something. This is good because you cannot have an expert basing a decision on information that is provably false to begin with. If you start with a flawed premise or false information, you're not going to come to a solid conclusion. The next witness was a gentleman who lived on Weed Street, and he had a big property with a fence all the way around it, and this property is close to the park outside of which Jennifer's Suburban was ultimately found on Lapham Road. This man had surveillance cameras all over the place. The police only asked him for the surveillance from 7 a.m. to 12 p.m. on May 24th, which I found interesting. It tells me they already had a working theory by the time they asked for this. Then there was an issue as to whether or not the video itself had been altered, if it was a continuous play, and now all of a sudden it's choppy. The defense was calling it a stop action. So they kind of went back and forth on that because the defense seemed to be concerned about the integrity of the exhibit. And the witness admitted that he actually can't say whether or not this is a fair and accurate representation of the video that was taken on that date because he never viewed that video until just recently. The defense and the witness are going back and forth. The defense kept using the term stop action, and the witness was saying, but my system is a continuous video, and yes, I see it's choppy. So I think there was a semantics thing going on there. Anyway, the judge interjected and stopped that. This witness testified that the only way onto his property is from Weed Street. And he was asked, can you get to Wells Lane, so Jennifer's house, through the brush of your property? And he said, well, no, there's wetlands between his property and where you'd have to go to get to Wells Lane. He was asked, what does Weed Street connect to? And it intersects with Frogtown Road, which is the route somebody would have to take to go to Jennifer's house. So they showed these little videos. At 7:31 a.m., we see several angles of a person on a bike driving by. And I was disappointed in what we could see. I was hoping that when they showed this video of the cyclist that we could at least maybe see the shoes, because there were footwear prints inside Jennifer's garage. And if the person riding the bike was wearing the same kind of shoes as that footwear impression, then that could tell us something. But it was just a black blob riding a bike. You can't make out who it is. And then here's the thing that sends chills down your spine. At 10:30 a.m., this guy's camera picks up a black Suburban driving by. The defense had no questions. And that was the end of the day for today. Trust your gut. I'll see you in the comments.